Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about debt collector lawsuits on what you need to make them prove their case, their claim. And I'm going to define that in a moment. But before I get started, I want to give you a word real quick, some encouragement, because I see the tides starting to shift. I've seen this before, and it's going to happen over and over again. Maybe it's happening for you, maybe it's not happening for you, but when it comes to the economy, when it comes to being saddled with debt, too many people are allowing outside information to either make them get paralyzed on moving forward and doing things that need to get done to be able to improve their situation, because they're just believing that there's just this huge recession that's about to hit, and can't make it anyway. And now I have justification because the news reports say that it's coming. And I'm here to tell you that you cannot live your life that way. No matter what is happening in the economy, no matter what people are saying, no matter what I'm saying, you need to understand that you control your outcomes. Now, I can't tell you exactly, like, if you do this, this will happen. If you do that, this will happen. Nobody can tell you that. That's what we call life. But what I can tell you is that if you work towards a goal and you're focused on that goal, and you're willing to do what it takes to get to that goal, you will accomplish that goal. So if you're trying to repair your credit, and your credit is devastated right now because maybe you had a divorce, maybe you lost your job, maybe you just, things had just turned upside down for you. I've been there. But I'm here to tell you that if you focus on the goal, pieces will come to you to solve it. And if you think about it, look at situations that you've made it through in the past. And you probably at that time didn't think you could make it through it, and you made it through it. You need to latch on to those types of things and stop latching on to what people are saying this is going to happen. Because they've been saying it's going to be a recession for years. And is it really a recession? Or things slow down, things speed up? Think about it this way. Can things continue to go up as high as they're going without it at least creeping down a little bit? Like, do we appreciate things if we sometimes have a little dip and then we're like, hey, we were in a better situation before, and you say, okay, well, I appreciate that more. So when you rebuild yourself, you're like, okay, I'm going to not get into that same type of, I'm not going to overuse credit cards, or I'm going to take care of my credit. I'm going to really pay attention to my finances. This is what life is about. And so many people right now, I see them quitting. We're getting a record number of people inquiring about getting sued by credit card debt collectors who purchase credit card debt. And one of the things I feel it from just overall from what I'm seeing out there with people, but also by the comments when people are talking about dealing with this stuff. It's either high fear and anxiety where they're just like paralyzed. I don't know what to do. I can't sleep. Can I get help? Can I not get help? I don't want to go to court against them. I don't know what to do. I just don't know what to do. And they reach out and we give them solutions on what they could do. But something that has changed is that I think that too many people are internalizing what's being said in the news about people going to be losing their job, people going to be losing their job, people not making money or not being able to pay their bills, not being able to do stuff. And they let that come in, and And then that's stacked on top of the situation that they're going through. And they're like, well, they're right. There's just no way out of this. They start thinking that way. And I'm seeing people starting to think that way. And I'm here to tell you, don't think that way. You can always make it out of these types of situations if you just understand, number one, understand what your ultimate goal is. Like, some people are of the mindset of fighting. Other people are not of the mindset of fighting. And I always tell them, hey, if you are not of the mindset of fighting, because it's going to be a fight, you're gonna have to go to court, you're gonna have to put up a defense, and you're gonna have to let the chips fall where they may. And you have a good chance of winning if you do what I'm going to be sharing with you here on the board here. But some people cannot stand to go through that. They don't have the nerve to go through something like that. And I always tell them, well, then you need to look at doing a negotiation to settle that credit card debt with the debt collector. You know, not to say that you don't do a full validation, not to say that you don't make them prove everything, but you know that your ultimate goal is not to end up going into court, because you just said that you don't have the nerve to do it. So if you don't have the nerve to do it, why put yourself in that situation? That's why I always say, wake up to your situation and what your goals are and what you are willing to do and not willing to do. So if you do not have the nerve and you don't want to go to court, you don't want to put yourself in a situation of having them garnish your wages at an amount that they want to do it, because you feel that you will lose that case because you're not gonna really put up a defense, then you need to approach them about doing a settlement. Now, most people will say, and I get this a lot, they'll say, I can't afford to pay them the amount that they want. And I'm like, you shouldn't pay them that amount. But then they're like, okay, I want them to give me a discount, and then I'm going to make payments on the discount. From experience, this can be done, but you're going to have to really, have some back and forth to be able to get that accomplished. Because if you think about it this way, you owe them, let's just say, for example, you owe a debt collector $5,000 for a credit card debt that they purchased. And they're like, okay, well, we'll settle it for half, 50%. If you send that to us, and you say, well, I don't have $2,500, I can make payments on it. And then they're going to say, well, if we're going to wait, well, then why don't we just, we're just going to charge the whole $5,000, because there's no incentive for them. They're going to be waiting on the payments. Now, you might be saying, well, maybe it is. It is, but it takes a lot of back and forth. And then you might say, well, I want you to delete it off my credit reports. They're not going to delete it off your credit reports if you're making payments to them. It takes away their leverage. So you need to understand where you're at in the situation. But it can be done. So if you're not of the mindset of where you want to put up a defense, go into court, you can approach a debt collector to do a settlement. You can offer payments, and it's beneficial to you to offer payments at an amount that you can afford to do. Get a new contract sent from them, so you have it spelled out how much you're going to pay, how much they're going to discount it for, and you make those payments and don't miss those payments. And then, but if you're trying to get all of this done and you say, hey, I'm going to do that, and I want you to remove it, what is their incentive to remove it when you're making payments? Now, they have an incentive if you're doing a settlement. And now, say, for instance, you owe $5,000 and you have $1,200, and you want them to do it, you should offer them the $1,200 and see if they would take that for payment in full, because one of the things that you do have in your back pocket, which debt collectors do worry about, is that you could maybe say, hey, I just can't do this, and I just want to file bankruptcy. I'm tired of all of this stuff. I got these other debts that are coming at me. So they don't know. So they're like this. They're like, hey, a bird in the hand is more than two in the bush. Is that what they say? Because it's right here in your hand, and they can make a deal with you and cut that deal and get the money that they can get right now without having worries of you either stopping payments or, where you don't continue paying them, or you end up filing bankruptcy, because that is an option that could happen, and they can end up, not getting any of the money, and they're paying money to be able to even do these cases. There's court fees and all types of stuff that they have to pay. So when dealing with debt collection lawsuits, let me just do a quick run through, a review on what you need to watch out for, so you can put yourself in the best position. Or let's look at it this way. Just listen to what I have to say, regardless if you are of the mindset of being able to defend yourself or not, and just look at it and see if this logically makes sense, to where you might say, well, at least I would give myself a chance if I would make them do this, if they're trying to collect on the debt by taking me to court. So the first thing when you're dealing with a debt collector is that you need to understand that they have to follow the rules according to the Fair Debt Collection Practices Act. They have to, number one, the first thing they got to do is they got to send you a letter demanding payment. You have a right to dispute that letter. It's called a dunning letter. You have to respond to them within 30 days, but if you do a dispute to them, they have to respond to you even quicker. They have a 5-day rule on responding to you. They have to, get that, and they have to, respond back. What they'll usually do is they'll, throw a couple of statements. They're going to put basically what they have to prove that they own the debt, or that you have to pay the debt, the amount. They usually don't send the affidavits and stuff like that at that point. They're just basically, putting it on the table. Hey, this is who it used to be from, which they put it in a demand letter. But when you do that debt validation, they're required to do an additional step. Now, something that you should pay attention to, because these are the things that can actually make them stop coming after you early. And I'm always about making debt collectors prove every step about the debt, but also looking at the way that they got the information to you. A lot of people don't know this, that a debt collection company cannot share your information with an outside third party without your permission. So when you get letters from that debt collector, you should scrutinize that letter to make sure that it doesn't look like it was from some mail house. You can look at FTC lawsuits, CFPB lawsuits, where they actually sued debt collectors for using third-party mailing organizations to mail out that information, because they're revealing your information to a third party. Now, they cannot necessarily call family, friends, relatives, your job to say, hey, we're trying to collect on the debt. They can say they're trying to get in touch with you, and they can leave a message. They can do that. But once you call them, so say you hear them that they did do that, you can actually call them and say, hey, I want you to cease collections. I'll get into that in a minute. You want them to cease communication by phone and to communicate with you by mail. And that's, before the process of them responding back with that validation, and you should put that in your initial letter. So what I tell people to do is, when you get that initial letter, you send back a letter, and I'm going to give you one at the end of this video on what you can use. But you send back a letter where you're making them prove everything. Well, where you're asking them questions, which in essence is making them show their hand on everything that they got to prove that you have to pay the debt. Also, if an attorney reviewed it, there's a lot of people don't know that when it comes to a debt, most attorneys, most debt collection law firms have not had any type of attorney review, and that is a requirement when they go to court. An attorney has to have reviewed all of that information to say, hey, this stuff is true, and this lawsuit can move forward. So step one, when you get that letter, you got to respond to it. If you don't respond to it within that time frame, you're giving them permission to put that information on your credit report. Number two, that scrutinize that letter. Don't just rip it open and tear it up, the envelope. Scrutinize it and see if it looks like it was sent from a third party, because you could be sending them a letter back stating that you've actually shared my information, my personal private data about this alleged debt with a third party by sending it through a mailing company. And you can, photocopy the envelope, and then that'll be up to them, because they're going to know if they did it or not. And more than likely, if they did do it, they would probably just send a letter back saying, hey, it was a mistake, or we're going to cease collections on that debt. There's other things that you need to be aware of, according to the Fair Debt Collection Practices Act, is that they cannot call you after certain periods of time. They cannot call you time and time and time again throughout the week. They're basically, I've seen it to where they're going to get away with it if they try to call you at least 2 to 3 times a week. That's if they didn't get in touch with you. If they get in touch with you, they can only call you 1 time per week. Now, you might be saying, well, they call me all the time on the stuff. They can call you 1 time per week if you don't tell them to cease calling you and to communicate by mail. They cannot threaten to sue you if they're not going to sue you. That's according to the Fair Debt Collection Practices Act. And they have to do the debt validation. They have to respond back within 5 days. Now, I want you to also be aware that when you do that dispute, it will put it into a dispute process with them if it's a reputable debt collection firm that's trying not to violate. It's going to put it into, basically, it's usually a 90-day process where they're going to say it's in a dispute, and they're going to be getting all the information. If they do get all of their information, they can take it, have it taken out of that process once they respond to you, but they're supposed to respond quickly. But I've seen it to where they didn't respond in the 5 days. Even if you do send the document to them saying that they didn't respond in the 5 days and they violated, they can say that they were trying to get the necessary documents to pursue you for the debt, and they do have a 90-day window on that. The only thing is that during that 90-day window, they can't do anything while they're waiting, and you can't do anything while they're waiting, because even if you're saying, hey, I'm trying to buy a house and I need to deal with this, I know I did ask for a debt validation, you'll be shocked. They'll be like, you can't settle that debt unless you say right now on the phone, and it is being recorded, that you attest to this debt. You're going to have to do that. So that's understanding. A lot of people are afraid when they say that, because they're like, well, I want to settle the debt, but then are they going to try to pull a fast move on me by, if I say I owe the debt, they take it out of the dispute phase with their company, are they going to say, well, you got to pay it all, they're not going to negotiate? No. From all experience that I've had, I've never had it go any other way. They're still focused on doing a deal, and they want to get their money. So you need to be aware of that. That's according to the Fair Debt Collection Practices Act. Now, the next thing is the assignment of debt rules. When debt collectors buy debt from original creditors, or you'll see this a lot where a portfolio company will buy the debt and then they will assign it off to another debt collection company. All of that stuff you need to pay attention to, because there could be problems with that. I've seen it to where one debt collector assigned it to another debt collector to another debt collector. Every time that they do that, that's a violation, potential violation of your privacy. Also, if you think about it, if one debt collector buys a debt from another debt collector, or they're assigned a debt from another debt collector, and then they take the one that got it, has it last, takes you to court, they cannot say that they got the documentation from the original creditor. They actually got the documentation from the debt collector that gave it over to them. And so this is like how you build your case to be able to fight against them, because you'll notice that the way that they try to prepare their documents are as if they got those documents directly from the original creditor, and they didn't get those. So you got to pay attention to, in anything that you see on what they give you for the assigned debt. The next thing is proof of purchase. So you want them to show you the proof of them purchasing the alleged debt from the original creditor. How did you get this? Where did, who did you get it from? All of that. They'll usually add that in there. They'll have a little document. It'll say proof of purchase. It was from the original. They'll have the original creditor on there, even if it's passed through another debt collector, they'll usually give that, and you got to be very careful. You got to watch because they'll be very, very tricky. I've seen this where you have the with my example where you had the original creditor, you had a portfolio company, and then you had a debt collector. I have seen where they had messed up on the documentation from that proof of purchase where it only had the portfolio company on there, and then you have another debt collector trying to sue you, and then you'll see where they try to fix some lines, and like it's crazy. But one of the problems that I see a lot with this document with the proof of purchase is that the original creditor is never going to say that that information was 100% accurate. They will never say it, and whoever gets that debt from the original creditor assumes all responsibility for every portfolio account on there, every credit card account that would be purchased in there. And so you will see, if you read it through on that proof of contract, it will actually state, hey, we do not guarantee this stuff. You're buying it as is. It's like going to a car dealer and it's like, hey, this one here, we got a warranty on, but this one over here is as is. The debt collectors don't care because they're banking on most people, which is what has been happening from the beginning of time with this stuff, is that 99.9% or 95% of the people end up getting default judgments. So they don't, they care, but they don't really care because it's like they're at a gambling table, and it's, they're the ones that's putting the cards out on the table because most people are not going to even show up to court. But that's one of the things that you got to look for, is that number one, it doesn't say anything about accuracy. Number two, who is actually the owner of the debt, or was it assigned over to a third party? Because that can open the door for you to be able to fight them a lot better. The next thing is you want them to prove a contract with you. Now, this is something that's common. Everybody talks about it on YouTube, and they're like, you don't have a contract with the debt collector. So you want them to prove the contract. So we always throw that in just to see what they're going to come back with. Obviously, they're going to come back with the proof of purchase. That's what they're going to utilize as their contract. Now, the next thing that you need to be aware of, which we discussed it a little bit, is a privacy notice. When you're preparing your defense against a third-party debt collector, you're going to want them to produce some sort of documents that show that they can have access to your private data. Point blank, how are you able to get my information? Show me the crossover document that was signed from the original creditor. Show me, if you're the third-party debt collector and you got it from a portfolio company, so now we have two situations that's messed up. And when preparing a defense, even though that middleman or that middle debt collection company or debt portfolio buyer did not come to sue you, that in essence, they need to be mentioned in there because they're the ones that's providing the documents to the third-party debt collector that is suing you. The original creditor is not. It's like it originated there, but really everything that the third-party debt collector that is suing you for, really all the information is from that portfolio company. So you need to be aware of that. And so you're going to be able to challenge the privacy with them. You're going to be able to challenge the privacy with the portfolio company. Now, the other thing is the balances, the payments, the interest rates, the credits, sign for all the charges. This is the information that you would want them to give to you. So if a third-party debt collector is suing you, give me all of that information so I can review it, because you're just bringing me a couple of statements, and that is not enough information for me to determine if this amount that you're claiming is the amount that I owe. So you see how I've kind of shifted there, and you see that if you utilize that in court, it is a very logical process, because you got to think about it this way. You don't want to set up some situation where you're up in there and you're just denying everything, and you're like, hey, this is, somebody just, I don't want to pay them. Because basically, bottom line, when you go in there to die and stuff, they're going to be like, hey, you just don't want to pay. But if you're asking questions that, even if this was the original creditor, like, show me all of this stuff because I need to recall all of these charges to equal up to this amount. Do you think that the original creditor would have a hard time getting all of that documentation over to you, or they say log in and you'll be able to see it all right there? So when an original creditor sells a debt to a debt collector, that debt collector is assigned that information. They are not assigned like we're just, coming after you, but we can always reach back to the original creditor for documentation. No, they purchased everything, and everything that they purchased, that's what they got. Now, there are three companies, three credit card providers, and it seems like some more are being added, but what comes to mind is Bank of America, American Express, Discover, and Capital One. So that's four that comes to mind who are hiring third-party debt collection firms to sue, but they're maintaining the debt. If you have one of those coming at you, you can still utilize this strategy here. And what that'll do is that'll get you into a position to be able to do a good settlement with them. But obviously, if you're dealing with an original creditor, they're going to have a lot of this information on there. Now, another thing you need to be aware of, especially when dealing with anyone, a creditor, anyone, most states will make a requirement that you're properly served, that it's in your hand. I've seen several cases recently be allowed to be reopened based off of that, but a lot of courts will still require that you have some sort of defense, because if you were not properly serviced, and not to say that it wouldn't happen in your state, but a lot of the times they'll say, well, if it's just over the service and we know that this was you and you did show up to court, we're not going to reopen it. But if you did not show up to court and you have the improper service proof and you have a defense that you're going to present if they reopen, you'll more than likely get them to be able to reopen your case. The next thing that we always ask for is full disclosure of the alleged account number, because you can't do anything with the partial account number. That's just not enough proof for you to know definitely that this account belongs to you 100%. And everything that we do here is to make sure either the claim is right or the account number is right. And that's just you getting all the data to be able to make a decision on what you want to do. The next thing is a chain of custody. We always want to know, and we talked about that a little bit earlier, is who has this? Who are the different portfolio companies? Some of the times it passes through multiple portfolio companies. Sometimes it passes through multiple debt collection companies. I'm on a list of a debt collection portfolio company who buys debt, and they've been sending emails, and I'm not a debt collector for those who think I am. I'm just on the list so I can give everybody here updates about what's going on with debt collectors. But they send out an email at least once a week asking other debt collectors who have portfolios that they're tired of running through or they want to sell, and then they would buy them because they're going to resell them out to debt collectors. So you need to be aware that that chain of custody matters, because who has this information? Is this information accurate? Are you getting all the information? That could be very valuable defense information to help you set up a defense to be able to beat these debt collectors. See, they don't expect you to try to come at them with this point. All they expect you to do is just to try to run and not have to pay the debt. So that's, in a nutshell, that's the way that you're going to be able to fight back against debt collectors. We just started from start to finish, before they try to sue you, all the way to if they do attempt to sue you. So if you need help with repairing your credit, please visit the www.thecreditrepairshop.com. Watch the video, what makes us different, so you can see my 8-point validation process, my two-phase settlement process. If you have debt collection lawyers trying to sue you, we have a link below this video. If you need your credit reports and scores, because a lot of the information that you're going to need to be able to either repair your credit or fight back against debt collectors. I could tell you one thing that would be on your credit reports that would be of very important value to you if you're being sued by a debt collector who purchased a debt, is that if you see in the comment section in your credit reports, if it says that the debt is canceled, that could potentially be debt cancellation when they use that term. So you would be able to say, hey, this debt is potentially canceled and forgiven by the original creditor. And you would have documentation to actually show that. And then you can also back that up by calling the IRS to see if they have canceled that debt. If you have debt collectors coming after you, which is what I had talked about earlier where I wanted to get you this letter, grab my 3-pack of letters. I have a statute of limitations letter to make sure that your debt is not past the legal statute of limitations. Go to my website, thecreditrepairshop.com. At the bottom, hit the blog and type in statute, and you will see the statute of limitations for all 50 states. If your debt is past the legal statute of limitations for original creditor or a debt collector to collect on you, and that's if it has not become a judgment. This is early in the, like if they've been coming after you, like in my state, is 6 years. And if the original creditor did not sue you and get a judgment in 6 years, you do not have to legally pay that debt. Now, they can call you. They can try to, see if you would pay it, but you have no legal obligation to pay it. I'm giving you that letter. You do not have to do a debt validation with that also. You do not. All you have to do is notify them that the debt is past legal statute of limitations and to cease calling you about it. The next one that I want to give you is my cease and desist collection activities letter. This will ask them questions to make sure that they can legally come after you for that debt. Now, some of the time they will still try to come after you because they don't believe that you either have the nerve or that or that you will put up a fight if they take you to court. But this will usually stop a lot of debt collectors. I get a lot of people giving their testimony on this letter that I've created. And it also has a cease communications in that response letter, so you can stop them from calling. They can send stuff by mail. And then if they try to go back and forth with you, I give you a debt validation letter where that will also help you out if they try to come back. You just might have to make a little bit of adjustments, but I give you the informational template to be able to go back and forth with them. I do ask for a donation. The link is below this video. I do ask for a donation on there. Because it can literally save you time, money, frustration, and you can utilize these 3 letters for numerous debts, not just for one debt. And so if you feel good about doing that, you can make a donation. And everyone who has made a donation on that, I thank you. I've had some very large donations that really showed me that you appreciate what I do for everyone on this channel. Thank you for your time. Please post your questions and comments. Please share this video. Please like it. If I really enjoy talking with everybody on this channel. This is Stephen A. Williams, president and founder of the Credit